An offshore trust is a sophisticated planning tool designed to protect a U.S. person's assets from creditors. Here's how it works. The U.S. person sets up a trust in another country, typically the Cook Islands. They then transfer the assets to a Cook Islands or offshore trustee company. The trustee company holds the assets for the benefit of the U.S. person. The key feature of an offshore trust comes down to jurisdiction. Unlike domestic asset protection planning, once the assets are moved to an offshore trust, a U.S. court and U.S. judge and federal agency no longer have jurisdiction. They no longer have control over the assets because they're simply not in the U.S. anymore. The offshore trust jurisdictions, whether it's the Cook Islands or Belize or Nevis, they have laws that prevent recognition of U.S. court orders. This is why offshore trusts are set up in those countries as opposed to something nearby like Canada or even a friendly country like the UK. It has to be in a jurisdiction that does not have a reciprocal treaty that would recognize a U.S. court order. Offshore trusts are very effective. In over 30 years of our law firm, we have not seen any client lose money that has been transferred to an offshore trust, no matter how aggressive the creditor. In addition, offshore trusts can often lead to better settlement outcomes of your legal issues. Once a creditor determines that the money has been transferred to an offshore trust, almost always they are more willing to settle for a reduced percentage of what is owed to them because the prospect of being able to collect against the assets in the offshore trust are very slim. Keep in mind that offshore trusts are not about hiding your assets. Money in an offshore trust must be disclosed and reported to the IRS every year. It doesn't affect your taxes, but it does need to be reported. In addition, if there is a judgment entered against you, post-judgment discovery will require you to disclose the existence of the offshore trust, even the trust agreement, and any transfers made into it. But disclosure of the assets in the trust does not lead to collectability, even after the creditor fully ascertains what is going on. There's still very little to nothing that the creditor can do to actually get into the offshore trust assets. Now, you may be wondering what happens if the offshore trustee runs off with the money. That's often a reason to stick with tried and true tested jurisdictions like the Cook Islands when forming an offshore trust. The Cook Islands is in fact the most heavily regulated trust company in the world, often even more than U.S. trust companies. Only a small handful of companies are even allowed and licensed to operate as trustee companies. They're all insured against theft and malfeasance. And in my experience, they are all very customer service oriented and want to do the best job for you, not only to manage the trust assets, but also to protect the funds. Offshore trusts are an expensive legal tool. They're expensive to set up. They require a few $1,000s in annual fees paid to the trustee company. But in my experience, there is nothing really as strong to protect your assets as moving money to an offshore trust. You'll have to decide whether the level of what you're trying to protect is worth the added costs. For people that have 1 million or more, especially in liquid assets, often the answer is yes.